Now, what can be done about this? Well, I'm part of what I call an effort that I'll call the litigation alternative. The Watts Tea Room Group referenced in the video began meeting in 2013. It was after the 2012 election to figure out what could be done. The 2012 election had pretty much documented what people suspected about how extreme the consequences of the gerrymander. There was also, had been an earlier case filed in Milwaukee. It was filed in 2011, right after this statute was enacted. And it moved on pretty fast, and it challenged the constitutionality. The plaintiffs in that case, I wasn't one, challenged the statute on various grounds, but not on the partisan gerrymandering ground. And that suit was largely unsuccessful, but it had been completed. It was finished, and the one thing that suit did accomplish, though, the state had taken the position in that case that the plaintiffs and the court had no access to any of the stuff that went on in that map room, the emails, the draft redistricting schemes, the memorandums, the directives from the legislative leaders to the drafters, none of that, which would normally be the kind of legislative work product that, if you're challenging the constitutionality legislation, lawyers would have access to. They said they didn't do it because it was all lawyer-client work product, or communications between lawyers and their legal assistants. Well, that court just blew through that rationale, said nonsense, this is just a ruse, and it's a long story. If you want to hear it, ask me a question. But the result of it all was that the court ordered the state to turn over the hard drives of the 3 computers that were the key drafting computers to the lawyers in that first case, one of whom is the lawyer in our case. So we started meeting in the Watts Tea Room. We had those hard drives. They had been doctored. We couldn't read them, but we had been able to find out that a forensics expert would be able to read them. We just needed some money to hire a forensics expert. So we sat in the Watts Tea Room. The first case had lost, but it hadn't raised the partisan gerrymandering issue. The 2012 election had happened. Democrats felt like they had no chance ever for a decade. And we had the hard drives. What are we going to do? Well, the reason the first case didn't bring the partisan gerrymandering claim is because other people tried to bring claims to the U.S. Supreme Court, arguing that other gerrymanders from other states were so extreme they should be unconstitutional under the U.S. Constitution. They'd always lost, although they came close, and there were some opinions. But it did mean that anybody bringing a lawsuit to try to challenge this apportionment as unconstitutional under the U.S. Constitution would have to go to the U.S. Supreme Court and get a precedent, a new precedent. That's a big undertaking, which is probably why the lawyers didn't bring that claim in the first case. It's a big undertaking. But we decided, the Watts Tea Room Group, well, there's no other choice, and we think we have some reason to think that we have a better chance than many, anyhow, of persuading the court, because we have extreme facts, and we have those hard drives. And they turned out to reveal quite a bit about, well, they did show that the legislatures intended to do exactly what they did for partisan reasons. We could show motive and all that kind of stuff from the hard drives. So we went around looking for some lawyers who would represent us all the way to the U.S. Supreme Court for what we were prepared to pay them, which was nothing. We were looking for volunteer lawyers, and we stumbled onto some, and that's covered a little bit in that video, and we brought our lawsuit.